So what I want to do is I want to flesh out the legal arguments behind the claims in my opening statement a little bit. So we started off in our opening statement, Your Honor, saying that they can't foreclose on a construction lien and that the evidence will show minimal compliance, if compliance at all, with the statute. So the first thing was no improvement. So we have the, I attached two cases to my brief, Your Honor. One of them was the Northern Pipe case, and that's a Supreme Court case, and all the following will follow on the analysis laid out by that. Plaintiff's counsel accurately represents that that case was about the 90-day deadline after completion of work or to file a lien. But the analysis was laid out for much more than that. The analysis was laid out to show us how the courts are supposed to regard any question of substantial compliance versus strict compliance. So as it comes to improvement, we have that, according to that Northern Pipe case, the analysis would tell us if substantial compliance were applied to that idea, the definition of improvement, would there be an absurd result or extreme prejudice or any type of prejudice? What we have is if a contractor or an alleged contractor only needed to substantially comply with the definition of an improvement, what we have is a situation where that becomes so broad as to allow just about anybody. And as the court pointed out, a carpet cleaner, I would point out a house cleaner, a snowplow driver. These are, you know, to allow the plaintiff to get this court to judicially expand the definition of improvement to include actions like ServPro performed is so far, it just opens up the floodgates to things, you know, that are clearly not contemplated by the statute. So in my brief, I also cited a case that talked about an analysis for when you have a list in a statute, and then that analysis was to take the listed items as a class. And so that's another way to look at it. You know, the class of examples provided in the statutory definition of improvement under the Construction Lien Act, Your Honor, is such that drying water is something that's much outside of the class of the same nature that cleaning a carpet or cleaning bathrooms or shoveling snow or plowing snow on the driveway. That's cleaning any of those things, but all of those things are outside of the class of examples. So, you know, that's just fundamental number one. And without an improvement, they're not a contractor under the statute. Without being a contractor under the statute, they can't foreclose on anything, but be it the lessee's interest or the owner's interest. Now let's get to that. So there is no contract with the owner. That's clear. They're arguing this agency relationship, but this is real property, Your Honor. I'm not aware of case law, just aside. I'm not aware of any case law that allows somebody to sign over the property of their mother without something more than apparent authority. There's got to be a power of attorney or something in place. And there was testimony that there was no power of attorney.
What about on the breach of contract claim?
The breach of contract claim, you know,
I mean, there's a clear breach of the contract.
There is a clear breach of contract.
By Krista.
By Krista, correct.
But what about the argument that Deborah is also liable for that because Krista was acting as Deborah's agent in signing that contract?
So it's not as strong from our perspective, admittedly, as it is regarding the real estate, but for a simple breach of contract or even an account stating, well, actually, I don't want to say that because that's different. So we have, if we just look, it's a slightly different analysis, Your Honor, because if we're just looking at the contract claim, we have clearly the contract is only signed by Krista. We have no reliance actually on the plaintiff's side to believe that Krista was acting as Deborah's agent. And this is evidenced by the bills that were only ever sent to Krista. They never attempted to bill Deborah. They didn't rope Deborah into this until they decided to move on the construction lien. So at no time can they prove that they actually believed, until they came to file a construction lien, that Krista was Deborah's agent, because they never demonstrated any reliance on that concept at any time. So, you know, it is a slightly different analysis, but it would be invalid as, you know, to show an agency relationship for those reasons, just on the breach of contract claim. Does that answer your question, or did I sidestep it?
No,
okay.
Go, continue.
Okay, so I'm going to resume back. Along the similar lines, the construction lien statute defines an owner and a lessee. As I pointed out in my brief, Your Honor, the lessee is what Krista is. The lessee is clearly defined on the act, under the act, as somebody who is not the owner, essentially. I don't have the actual language in front of me, but there's no question that the act defines this relationship between Krista and Deborah, and that Krista is a lessee. If we're going to say that, oh, it only requires that we substantially comply with the definitions of owner and lessee, again, that just reduces the whole statutory scheme to absurdity. In the plaintiff's brief, they mentioned that a co-lessee can bind a co-lessee, but they're not saying it for that proposition. They're saying that a lessee can bind a or an owner because of it. It really makes no sense, Your Honor, where we have a statutory definition, and yet they're saying that the statutory definition doesn't apply to this case, essentially. And that cannot be any further from the truth. As to the lessee interest versus the owner interest, plaintiff in their argument a moment ago said something along the lines of, that's just not how construction liens work. They can't have a foreclosure on the improvement, but that's exactly what the statute requires. The statute says that if there is a contract with only the lessee, the only thing entitled to be foreclosed on or liened against is the improvement. So they can't argue in good faith that that's just that's not how construction liens work, because it does, because the statute says that's how it does. So then, you know, the next issue, the next fundamental issue about this construction lien thing is that there was no lien filed within 90 days. So again, they're saying that we should take, well, I mean, any material supply, I mean, a fair reading of the statute would be that any material supplied or labor performed must be in the nature of the work that's being done. If they just left a piece of equipment behind that's not being used, not plugged in, it's just there because they don't have a need for it and haven't picked it up for a month, that's not of a nature of work being done or materials or labor being supplied. And as the court pointed out in its questioning of the plaintiff a moment ago, it wasn't even related, that piece of equipment, to the work that they were contracted for. There was so just going through the first three most basic requirements of a construction lien, Your Honor, they fail so dramatically that there is no arguable merit to the point where it's vexatious under the construction lien statute. As I noted in my brief, the standard for vexatiousness is found in the court rules for the Court of Appeals. Our appeals court has applied those standards because that's where they could find in the existing law vexatiousness, and applied it to situations like ours. Because So these fundamental definitions aren't being met. There's no good argument for expanding the idea of substantial compliance when these things, when substantial compliance would just open a floodgates to absurdity if we do what the plaintiff wants. The ending of work a month after is similarly an absurd claim with no real arguable merit. And not to say arguable merit doesn't mean that no attorney will get up and say, X is Y and Y is Z, because that's making an argument. What we're talking about is arguable and a good faith standard that this is right under the law and this is what the law demands. And in this case, we just don't have that. We're not even close. And then we have the other requirement of the Construction Lien Act, no service of lien attempted within 15 days. They got the lien filed on August 5th. It's timestamped by the Register of Deeds. For us to believe that it took the Register of Deeds from August 5th until September 3rd to return that deed is another, it's calling for the court to just believe unreasonable things. It's just not it. Again, they're so far pushing the boundaries as to what these statutory scheme is there to do that it's alarming, and it needs to be severely sanctioned by the court in the form of vexatiousness finding and or a frivolity finding, because frivolity really is, along the same concept, no arguable legal merit. Still on the filing of or service of the lien within 15 days of filing. It didn't even try. What we're talking about with the case law cited by plaintiff and attached to the brief and whatnot, we see substantial compliance is treated by the Court of Appeals and the Supreme Court to mean they tried something, they did something. It just wasn't exactly what was required. But here with this 15-day service of lien requirement, they didn't try anything. They didn't do anything that could be showing a step in the right direction. They didn't do anything for almost a full month, like 28 days after they should have. Similarly, there's no sworn statement prior to filing the case. I can see, there is a fairly persuasive appeals case attached to to the plaintiff's brief, Your Honor.
I mean, as to the 15 days, the record evidence we have today in the testimony is that the standard practice is as soon as they get it back, they send it out. And so that's what they did in this case. And but that your clients didn't pick up the certified mail. So the plaintiffs say, yeah, we took an effort, meaning we send it out certified mail as soon as we get it. And to the extent that that wasn't strict compliance, it was substantial compliance, and your clients are not prejudiced thereby because they even refused to pick it up when we sent it to them.
So, well, there's a couple different things going on there with the court's comment. Let me address one. And so what we're talking about here is the substantial compliance with the 15-day requirement and the absurdity of plaintiff asking us to believe that, oh, we sent it out as soon as we got it on September 3rd. So that's a different ballgame than, hey, we sent it out as soon as we got it on September 3rd, and it's totally reasonable for us to have received it 28 days after filing it. It's apples and oranges, Your Honor, insofar as the unbelievable unbelievability factor has to be weighed very heavily here. The unbelievability that it took the Register of Deeds or the U.S. Postal Service 28 days to deliver a file deed. So I'm saying it's so unbelievable.
I have no unbelievability about the delay of the U.S. Postal Service. Since COVID, every attorney knows we used to rely on that a lot more than we really should rely on it now. I don't know why that is, why 5 years later it should be that way, but I can't tell you the number of cases I see where delayed mail delivery is a factor in the case. Happens all the time.
I don't know. So, I'm fine moving on from that issue if the court wants to take that into account and weigh that more heavily than my arguments.
The sworn statement you were getting at.
Yeah.
So the purpose of the sworn statement is to let them know, like any other, who did the work,
Right.
what work they did. And here, I mean, really, there's.
And we know who did the work, okay?
Right.
And we know.
So if that was the only deficiency.
If that was the only deficiency,
you probably wouldn't win and strike me down.
I would not run my flag up the flagpole just on that, but it's just an example of the gross delinquencies and the clarity of the statute, Your Honor, that says no case can be filed unless this is done prior to the filing of the case.
So fair enough. It's for illustrative purposes of their complete disregard of the statutory requirements.
Yes, that supports a finding by this court that their actions have no legal merit in this regarding the construction lien, imposition, as well as foreclosure, vexatiousness, as well as frivolity. So as to that one issue, I'm sorry, I'm taking a lot longer than I thought I would.
Okay.
But as to that one issue, number one, we'd ask the court to void the lien and remove it, as well as the notice of dependence that's been filed. We'd ask the court to also, because the court would be justified in making a finding of frivolity and vexatiousness under the construction lien statute, my client is entitled to request reasonable attorney's fees, and under the court rules regarding frivolity, similarly. Okay, so we talked a little bit about the inability or just treating this as a breach of contract action. And I don't want to go too far into it, but as mentioned, when we took a tangent a moment ago, it was only Krista that signed the contract. The bringing an action against Deborah is frivolous because there's no contract with Deborah. So there's no, even again, we have the difference between what an attorney feels like arguing, but what's actually arguable to determine what's frivolous. And even though the plaintiff's attorney can and did argue agency relationship, we don't have any reliance by plaintiff, no evidence presented that they relied on Krista as Deborah's agent for purposes of this breach of contract, because the plaintiff never billed Deborah, never attempted to contact Deborah, never did anything with regard to Deborah. As to the issue of the account stated, that same logic applies, but it's even stronger because they never billed Deborah. For an account to be stated, there has to be a presentation of a bill at some level. And so it's absolutely lacking in arguable legal merit for them to claim that they have an account stated with Deborah when they never tried to bill her. That right there, I think, is our strongest argument for frivolity, Your Honor. Now, while we're still on the topics of these contracts, this contract, we want to talk about the Interest Rate Act. So we have shifting categorizations by ServPro as to what interest is. I believe in argument they said it was a charge, a finance charge, or a cost of credit, and then a time price differential. But here we have page 1 of Exhibit 3, where it says, let's see, 1, 2, 3, 4, in the 4th paragraph down, last sentence.
It's not a time price differential. It's a penalty interest for late payment.
Yes,
The way it's
okay.
stated. Because it doesn't say, hey, we did the service for you, take your time and when you want to pay it, and it's going to cost you this much per month to have that credit.
Yeah,
That's a time price differential.
correct.
And this ain't that.
And this ain't that.
Okay.
Correct. Thank you.
I'm with you on that.
Okay, thank you. And so, yeah, I guess I can move on from, well, I mean, just to be clear, because it's not a time price differential and it is a late payment penalty in interest.
So what should I do about that then?
Well, I think you have to do what the statute requires, Your Honor, and the statute requires no interest. Easy peasy. Statute requires attorney's fees. You know, I work for legal aid, in case the court or anybody here didn't know, we don't charge attorney's fees to our clients, but we have the ability to still collect attorney's fees, especially in egregious situations. And at any time up to trial, we could have negotiated away that claim. But here we are, and we've now spent, did they remove the clock from the room?
Yeah, we don't have a clock.
We've now spent,
It's noon.
3 hours, in addition to hours and hours and hours of preparation, when all of this could have been avoided if if it could have been made clear in plaintiff's opinion that they were barking up the wrong tree here. So even though we could have agreed at any point prior to today, probably, or even as of this morning, to not try to follow through on our statutory claim for attorney's fees under the Interest Rates Act, I think that ship has sailed, and I think we need to seriously push for that, because in addition to just the time expended by me and my clients, and we also have the greater public at large. If ServPro is doing this and this is their standard contract, how many people have ServPro already charged this usurious interest rate to? How many people will they continue to do so if they just get a slap on the wrist from this court and don't suffer from the extreme penalties that the law provides? We need to protect the public, and that brings us to the Consumer Protection Act claims as well, Your Honor. So the crucial language in the Consumer Protection Act statute is causing a probability. So we have to step in the shoes of each other or as a reasonable person. I don't believe that this has been fleshed out in the case law as to how do we.
But your claim under subsection O, causing a probability of confusion or of misunderstanding as to the terms or conditions of credit, if credit is extended in a transaction, that conflicts with, you're claiming under the interest rate portion that this was not a credit extension.
Right.
So your subsection O claims, if you prevail on the Interest Rate Act, would fail under the Consumer Protection, under subsection O.
Agreed.
Okay, continue.
So, sorry. Again, we're talking about the probability of confusion, but confusion or misunderstanding.
As to the legal rights, obligations, and remedies of a party, that seems to be
correct.
Perhaps your strongest claim under the
Thank you, Your Honor. So what we're looking at is probability. We're looking at preponderance of the evidence. What does the finder of fact believe is more likely than not as to whether there's a confusion or misunderstanding, or whether there could be the probability of confusion or misunderstanding? So here we have a contract that says they have to pay 1.5% per month interest. 1.5% sounds so little. Being a reasonable person, looking at this and thinking, wow, this is actually very low. It's de minimis insurance or interest. It's de minimis, finance charge, whatever it is, it's de minimis 1.5% per month. So no reasonable person is going to, do a full analysis on the spot as to what they're signing, if they do even read these contracts, and learn that 1.5% per month times 12 months adds up to 18% per year. And that's far and above anything that could be considered de minimis. And it's far and above what the Interest Rate Act would allow. And so there's a high probability, much more than a preponderance of the evidence, that a person agreeing to 1.5% per month will be confused as to their legal rights, because this is not saying that it's usurious. It's on the surface not appearing to be usurious, only with somebody who's willing to invest the time to do some, math multiplication in their mind or on paper, would a person see that, hey, this is high. And even then, they might not know that it's usurious and contrary to law if they have no basis, no legal education or understanding. So now, along those same lines, we also have a claim under the Consumer Protection Act that they charge grossly excess price by charging the usurious interest. And because they characterize this price, as a time price differential, the cost of extending credit, which I believe, is clearly not the case. This is the cost of their services built in, this 1.5% per month charge, which is grossly in excess to anything allowed by law. We also have the issue of the Consumer Protection Act's prohibition on entering into agreements without getting a clear waiver of rights, entering into agreements that waive rights without giving clear waivers. So a clear waiver of rights, Your Honor, would be not a sign here and initial on the bottom of this page. It would be something of the nature that we see in contracts from time to time of separately initial contracts. So for example, we have paragraph 9, page 2 of exhibit 3. I'm sorry?
The jury trial waiver?
Yeah. So we have that, and that's in bold, but is that a clear waiver of rights? I think the strong argument is that it's not, because it's not asking for a separate initial or signature as to that paragraph. The only initial this page or signature this page asks for is an initial at the bottom for all of these terms. So that is not a clear waiver. Similarly, if there was going to be an argument that 1.5% per month was going to be agreed despite what the Interest Rate Act said, and it was going to be clearly waived if the Interest Rate Act or any other law allowed them to waive it, in order to get away with that, there would have to be a similarly clear waiver insofar as a separately initialed or signed paragraph relating to that term. So then we have the idea under the Consumer Protection Act as to ServPro misleading or deceiving the Wileys about a material fact, and the material fact, and that we've been arguing and testifying back and forth, one of many, and one of the more important ones is, when did work stop? We have ServPro's belated efforts after sending their bills that end on April 29th or 30th, and never sending another bill in the future for any work or labor or materials supplied after that date, leading the Wileys to believe that work was done on April 29th or 30th, the last time that they actually billed for something, and then saying, when they file a construction lien 4 months later, 3.5 months later, that, oh, by the way, we kept doing work or supplying materials or labor until May 30th. That is a clear deception, Your Honor, and there's no argument the plaintiff can make that will remedy that deception or explain it away. As the court so aptly pointed out in its questioning, whatever work ServPro alleges that they did from April 30th to May 30th wasn't work of a nature that they contracted for in the first place, and that could have arguably given rise to a construction lien if the other prerequisites, the definition of improvement, definition of owner, definition of lessee had been met under the act. So under the Consumer Protection Act, actual damages would be the $2,500 that they're being sued for. Attorney's fees would be, my attorney's fees. Both of those things can and should be ordered under that act for these violations. Alternatively, if the court didn't find that actual damages were warranted, the court has the ability to order $250 per violation that it may find of the Consumer Protection Act. So I think I touched all the issues that were raised today. So thank you, Your Honor.
Okay, thank you, Mr. Chairman.